हेलो दोस्तों, मैं लीगल कॉर्पोरेट से एडवोकेट शैलेंद्र पटनायक आप लोगों को स्वागत करता हूं। ये वीडियो नेगोशिएबल इंस्ट्रूमेंट एक्ट का ऊपर मैं बनाना जा रहा हूं। आजकल ये कॉम्प्लेक्स सोसाइटी में जब चेक डिजोनर केस सब समय होता है तो एज ए लॉयर one should be very cautious how to win a check bounce case, for which this presentation. My dear friends, when a client comes to you with option, with a problem that his check has been dishonored, and the lawyers asked him, what is the amount of check which has been dishonored? He says it is 15 lakhs. Sir, 15 lakhs check of mine has been dishonored. So there are three stages when a client comes to you. But when he says about 15 lakhs, immediately the lawyer responsible word that it's very difficult to win a check bounce case, but I can delay the case. In the meantime, you try to settle it, or I will try my level best. But I want to tell you that in all check bounce cases, the complainant is not going to win. The defense may also win a check bounce case if the advocate is very tactful, knowledgeable, and have a clear knowledge about the Negotiable Instrument Act. So my dear friends, when a client comes to you, he comes with three options. He comes with three times. What is the first occurrence? When he has given a check and he knows that the check is going to be dishonored, he comes to you for a suggestion. Ki, sir, my check is going to be dishonored. I have given him a check of 15 lakhs. What should I do? This is one stage. In the second stage, once the legal notice was issued, after the check is dishonored, after getting the legal notice, your client comes to you. Sir, I have given a check, it is dishonored, and now I have got a legal notice. What should I do? In the third stage, sometimes once the case is filed, the client comes to you that, sir, my case is already a case has been filed against me. What can I do? A check has been bounced for 15 lakhs rupees. So at this three stage, either of one stage, the client comes to you. I will tell you from my practical experience how the lawyer should handle the case in a negotiable instrument act, particularly in a check bounce case. देखिए दोस्तों, if he is coming after giving a check, he knows that this check is going to be dishonored. But as a lawyer, you have to suggest him. What should he do? He knows that the check is going to be dishonored. So you suggest him to write a letter to him telling that his stocks are all in a destroyed condition. I have incurred a lot of loss. So I don't want to continue my business with you. So I request you that such and such number of check, such number, the number and the amount which I have given to you as a security check may kindly be returned within immediately the moment you receive this letter from me. Otherwise, I am going to file a case against you for cheating and doing fraud with me. And if you don't get the check back, you advise your client to file a case against him, that to prove that the check was purely given for a security purpose in advance but not for any debt. And you have been cheated by the stocks as not were in good condition, so you have been cheated. So you advise him like that. But if he comes with a legal notice, then as a lawyer I will suggest you, this is my own suggestion, that you must reply the legal notice. You must reply the legal notice stating that the check was not against any debt. You have given a check in advance for which you have to show the agreement, the everything, whatever you have got in favor of your client. You write that and you tell him that this is a simple security check, or you have given this check in advance to continue with the business. So there is no debt. So I will file a case against you because of you are misusing by using the security check which I have given in advance, and there is no debt against me. So whatever you have got to prove that there is a, because the law says that, because why I am telling you have to reply to a letter, the lawyer must have some logic. The logic is that the Negotiable Instrument Act says that the complainant has to prove his case that there is a debt for which this check has been issued. That is the onus on the complainant who has filed a case. And it is the onus on the party whose check has been dishonored to prove that there is, the check was not given against any debt. So this is the law. If you can fight and prove that there is no onus on your part, there is no debt against you for which this check is dishonored, and it is a security check or advance check given on good faith, then probably you had, there is no case against you. For which in the trial I will tell you how you have to deal with when the case will already start. Then in the third stage, when there was a summon, and by receiving the summon and a petition, he comes to you that this is the petition I have received and a case has been filed against me. Then as a lawyer you have to note down certain things. You have to ask him his name and address, the address of the party to whom he has issued this check, when he has issued this check, whether he has issued this check or not, and whether in the check the entire thing was filled up by him, when he has presented this check, and what is the date on the check, and whether it is a blank check or there was some date. So you should ask him that you want certain documents before fighting this case or contesting this case. You want certain documents. What are the documents? You want the check, you want the petition copy, you want the Dishonour memo of the bank, and you have to receive the legal notice. All these things you have to receive from the client, from your client. Note down all this in a paper. My dear friends, first you have to see one thing. When the check was given, or what is the date on the check, whether within 3 months from the date of the check has been presented or not. If the check is not presented within 3 months from the date of issue of this check, then you don't have a case. The complainant doesn't have a case, and you are going to win the case. This is not maintainable. Second, if he has issued a check and the cheque has been dishonored and the date of dishonour of the cheque and the cheque of receiving of that dishonour memo by the person. From the date of receiving of that dishonour memo till 1 month, within 1 month, he has to give a notice to your client. You mark it, if he has not given a notice within 1 month and there is a delay of 3, 4, 5 days, then certainly no negotiable instrument act is maintainable because this is the statute. There cannot be any extension of time. Try to understand that. And third, within 15 days of receiving that legal notice or notice, if your client has not given any reply, and after that 15 days, within a month, the case has to be filed. That is also a statutory period. If it has not been filed and he has not obtained he has not condoned the delay, in that case, also there is no case. But first thing, if the legal notice is not issued or any notice is not issued within 30 days from the date of dishonour of the cheque, my dear friend, there is no case. This is all about the Negotiable Instrument Act. This first you note down. You also note down that what is the transaction, how it started, how he knows the person, whether this is the only cheque or there are other cheques. All these things you mention in your act because it will help you while conducting the trial. And once he receives the summons, he has to be present on the case because this Negotiable Instrument Act is a bailable offence. So bail is a mandatory. So once you go to the court will provide you will give you order you for a bail. So there is no problem in that. You appear and you can also you can file a petition under section 205 asking that your client cannot appear due to his bad health or some other reason, and that also you can obtain from the court. And once you get all these things and 205 is allowed, now in the meantime you read the plaint, total plaint copy, you try to read it. You find out what are the lacunas in that, on what ground he has penalized you for that amount, for that cheque. Once all these things is over, you appear in the court and then you get a bail. Then on the second phase, in my next video I will tell you how a good lawyer can conduct a good trial in the Negotiable Instrument Act so that he can win a case. First of all, these are the lacunas. If that is there, you are going to win a case. But you collect all information, suppose there is some bill, you get those bill copy, you get the invoices, you get the transport sheets, whatever is there, and you get also give a letter, give a petition in the court to give you all the documents you need. Suppose that suppose there is a ledger, you want the ledger copy, the statement of accounts, you ask all these things. So the court will order the party to produce all these things. By that you get another date. Until he does not produce all these things, or he express that he is not able to produce all these things, then it is a positive factor for your case. So you first ask these things, pray in the court, giving a petition that you need all these documents for conducting the trial. So in the next video I will tell you that how to conduct a trial in the Negotiable Instrument Act. But first you mark these things and advise your client properly. Thank you, gentlemen. Thank you, friends. With this, I thank you all and request you that if you like my previous video or this video, you can give a like, you can subscribe my channel, and you can give a like status to me. Thank you all. Thank you very much.